Gene Keating, what's going on?
Taxes and inflation. And insurance fraud.
You're here, we on here talking about you and everything. Somebody said, they said, yeah, I went and listened to some of this Gene Keating stuff, and it sounds just like something everybody else is talking about. I wanna introduce you to my listening audience, everybody out there on high frequency, listen to High Frequency. This is Gene Keating. Welcome to High Frequency Radio, Gene. How you doing? How you doing this morning?
I'm doing good. I had a good night's sleep. I dreamt about the changes that are coming about. You don't even have a government anymore. Everybody thinks you got a government, and everything's been privatized since it actually just started in 1861 under the Insurrection and Rebellion Acts of there's March 3rd, 1861, and June 5th, 1862. They put the United States. They put everybody under martial law. And what they did is they did the Reconstruction Acts, and they didn't seat the South in the Senate and the House, but you didn't have a quorum. So you haven't had a government, a constitutional government, since 1861. What you got is a bunch of everything is run by the corporate money interest. And what I mean by the corporate money interest is every court, and I mean every court has a DUNS number, NAICS number, CAGE code, which is the government activity code. And the CAGE code, I actually have a CAGE code on the United States District Court. And they're all privately owned trading companies, owned by the United States Attorney's executive offices out of Washington, D.C. They're not courts at all. So everybody goes, so they work on contract. And I've had a judge tell me this off the record. He didn't tell me, he told one of my students, and who's deceased now. He told one of my students that all of these courts, ALL, operate under Admiralty Maritime Law. And he says, if you ask me that publicly, he says, I will deny it. And the reason being is that nobody, and I have a case that came out of it's Black Diamond Company. It's a case that was decided, and even in there, the Court of Appeals said that even judges don't understand that it's all Admiralty Maritime Law. And I've been studying it and teaching it for 50 years. And I started out learning from Lee Brobst. And he got to a point where he couldn't answer my questions, so I started doing my own research. And I had a guy here in California told me you can't bring Admiralty Maritime Law in on the land. And that's not what the Genesee Chief case says. It says they can bring it if you have a maritime contract. See, they used to have what they call the high water mark, which is the ebb and the flow of the tide. And the high water mark ended at the county level. You couldn't come into the county, bring Admiralty into the county. And if you read Professor Roberson's Federalism and Admiralty, which I pass out to students, and they quit printing the book, and it goes into the Court of Common Pleas, and the head of the Court of Common Pleas was constantly petitioning the king for impingement of the Charles Townshend ran the British Board of Trade, and he was constantly bringing impinging upon the common law by coming into the counties, bringing admiralty maritime law into the counties. And Lord Coke, who's the head of the Court of Common Pleas under the King's Bench, was constantly suing Charles Townshend for impingement of admiralty upon the counties. And so what he did is he petitioned the king for a remedy, and the remedy is a writ of prohibition. And I've used writ of prohibitions, and I've won every one that I've used. And how I did it is I went to the California Supreme Court, and they have a writ clerk, and all she does is handles writs. She doesn't do anything but handles writs. And I said, give me a habeas corpus and a writ of prohibition that have been granted so I can see how they should be put together. So I got a copy of a habeas corpus and a writ of prohibition. And so I asked her when I was in there, I said, how many habeas corpuses are filed? She told me that 3,000 habeas corpuses a week go through the Supreme Court. And only 1 out of 3,000 is granted. And she says, it's not because they're not entitled to a remedy or relief, it's because they don't know how to put a writ together. So I did a writ of prohibition. And this is in a criminal case. I did a writ of prohibition in a criminal case in Superior Court. And I went in before the judge, and the judge said, first thing he asked me, he says, what attorney did this writ of prohibition for you? He told me it was the best writ of prohibition that he ever read. He granted it. He granted my writ of prohibition. People don't know how to put documents together, pleadings.
Okay,
and they don't read the rules. Number one is they don't read the rules of court. I had a criminal case that I was involved in back in the 1970s. I stayed up all night memorizing the evidence code. I got everything excluded from evidence. They couldn't get anything into evidence. I objected to everything using all the rules of evidence. So I know all the rules of evidence and what they can get in. And what people do is they allow documents in there that create a presumption that something happened when it didn't. They work on presumption. And if you go read 1-201, it says, the trier of the fact shall find the fact to exist if nothing is put into the record to show, no evidence is put into the record to show a contrary finding. So everything is evidentiary. And there's no, when they do these, for instance, these mortgage foreclosure cases, they're creating the presumption that there was a mortgage by putting a note in there and a deed of trust. And of course, and it says that they loaned you money. In fact, they assert that the loan is in default. Well, and so what I did is I brought a program called Dragon Naturally Speaking, which prints words when you speak them. And I had the 7.0 version. They're clear up to 12.0 now. And I printed out a deed of trust by reading the entire document and speaking every word in the document. And I looked at this document, I said, you got to be kidding me. This is an unconscionable contract. Well, for one thing, if you look under paragraph 3, under payments, it says that any default in payments can be paid at maturity. So how could the loan be in default if you can pay off any deficiency at maturity? If you read the note, that's why it's a security, not a note. It's because it has more than a 9-month maturity date on it. And under 15 U.S.C. 78C810, any note that has a maturity of more than 9 months is a security. And they have a rule called Rule of Statutory Construction. And it's expressio unis exclusio alteris. And what it says, that's a Latin phrase, and what it means, and they've been applying this for 150 years. If an instrument is included in the definition of a note, it's excluded from the definition of a security. And conversely, if it's included in the definition of a security, it's excluded from the definition of a note. So you're not dealing with a liability instrument, you're dealing with a financial asset under Article 8. And when they sell it, they become the debtor under Article 9. Unless they file a UCC-1 financing statement showing that they still have a security interest in the item that was sold, or the collateral. And when you sell a note under Article 9, it becomes collateral. And if you read 9-318, it says that if you sell collateral, you don't maintain any legal or equitable interest in the collateral sold. So who's the creditor? The creditor is the buyer. And they never tell you that. Adam Levinson, and most people have never heard of Adam Levinson. You should read his treatise on Article 9. He says that technically a deed of trust or a mortgage security agreement is not a mortgage lien at all. It's a sale and repurchase agreement. And what that means is that you're actually selling the property by transferring title and ownership at closing. And if you do research on the words grant and convey, and I don't care if you're doing it to a trustee or if you're doing it to a beneficiary as a mortgagee, then you're transferring title and ownership. Well, if you read your Revenue and Taxation Code, and I'm going to use California as an example, 480.03 says that there has to be a preliminary change of title and ownership form filed and recorded with the county recorder's office. And it's called 502A. And then if you go into this has to take place before there's a transfer of funds into an escrow trust account with a financial institution, which constitutes closing, what they call closing. And if you study this, you'll find out that there never was a closing of escrow by transfer of funds to an escrow trust account in a financial institution in the state in which the mortgage is located. That's because there never was a mortgage. There never was a lender. There never was a mortgage. In fact, Michael Greenberger, and you should listen to him. Michael Greenberger is the head of the Futures Trading Commission, Commodity Futures Trading Commission. And he's an associate professor at the University of Maryland in Baltimore. And he teaches law. And he says that all title insurance policies are security derivatives. They're not title insurance policies. And you couple that with the fact that they're not transferring title and ownership as a sale and repurchase agreement at closing, there's no collateral for a mortgage. And I had 3 cases, commercial loans that were totaled $5.5 million in New York City, and I got all 3 cases thrown out. And I talked to my client, had attorneys, because she doesn't know how to represent herself in court. So she hired some attorneys, and I started talking with her attorneys, and they said, well, we don't do. I brought this to their attention about the transfer of title and ownership, and they said, they don't do that anywhere. And I said, I know they don't. That's why the lender, the servicing company, doesn't own the loan. They don't own the loan. They don't have any security or collateral or a mortgage lien. That's a true sale. And if you read 1214, it says that any transfer is void against subsequent purchasers for value and consideration of the same property that's not recorded. So if they don't record the transfer of title and ownership, it's void against any subsequent purchaser. What do? They sell the loan at closing. And they're allegedly, all of this started as a pay forward through a REMIC. And what they do is the investors set up a REMIC, which is a real estate mortgage investment conduit. and they call it a REIT, then they're supposed to qualify it by filing a 1066 REMIC tax return to treat the REMIC as a real estate investment trust. And they never filed the 1066 REMIC tax return because I've asked them for it, and they don't have it. So that means there's no REMIC or real estate investment trust. That means that all of these securities or derivatives that they sold are in default, and they're not. They were never transferred to the REMIC at closing, so they were never securitized as an off-balance sheet item. So that you don't have a REMIC, you don't have a securitization or an off-balance sheet item. So what the hell's going on here? You got major fraud going on. So I had this. So what I did is I found this company, and they're called Paladin here in California. They do forensic audits, and so I found one of their audits, which is 620 pages long, and it has a flow chart in it. I wish you could look at this flow chart, and they actually tell you in there what they're doing, and they refer to these as insurance. They're all insurance contracts. And so I told him what I thought was going on, and I asked him how long it takes to do a forensic audit, and he says it takes about, we can do it as quick as 3 or 4 days if you need a rush on it. But he says traditionally it takes about 3 or 4 weeks to do it. And I said, well, what do you charge? And he gave me the fee for doing a forensic audit. And so I asked him, I said, how many auditors do you have? He says, we have 23 auditors, and he says, all of them are mortgage bankers. All of their auditors, their 23 auditors that they use for forensic audits are all mortgage bankers. So I told him, I said, I'm going to tell you what's going on with these mortgages. And I told him, and he listened to me for about 15 minutes. I went into a 15-minute dissertation. You know what he told me? I was 100% correct. And what I told him was going on is they forfeit the note as a bond to the title company for the default. The default occurred at closing because they never transferred the title and ownership in the loan to the lender, and they never transferred the loan documents to REMIC, so the loan was in default at closing and unsecured. So they're selling defaulted derivatives to investors. And so what you're doing is you're actually acting as the insurer. Go read what an insurer is. An insurer is a person that indemnifies somebody against contribution. Contribution is an extreme form of indemnification. And conversely, when you indemnify somebody, you agree to insure them against loss or risk in the event of an imminent default. They engineer all these loans to go into default at closing. When I file paperwork, they take every one of my cases off calendar because they don't want to deal with this because it involves a tax issue. They haven't paid the taxes on the capital that they're holding. So what they do is they forfeit the property to pay for the taxes on the capital that they're holding. Because, number one, they have to create the REMIC as a real estate investment trust. And then they have to pay out 95% of the capital as interest and dividends to investors in order to get the unified tax credit. And they never do that. And they never file a statement to treat the property as foreclosure property under Treasury Regulation 1.856. They have to treat the property because that's a disposition of property, which is foreclosure property, and it creates taxable income. That's why this whole thing is a tax issue. And if you read 4975 of Title 26, you have what you call safe harbor provisions, and they have to transfer the loan documents because the REMIC closes up within 90 days, so they have to transfer the loan documents to REMIC within 90 days, and they never do that. And I've actually got them where they're transferring them after the 90-day prohibition, which means it was done beyond the safe harbor provisions. Now, so when they do that, it carries 100% tax penalty for the prohibited transaction and a 15% penalty for the violation. So you got two taxes. You got 100% tax on the prohibited transaction, and you got a 15% penalty for the violation under 4975. I've shut them down. They take these cases off calendar. And judges don't even know this stuff because nobody ever brings it up in court because nobody reads anything. If I've learned anything in my 50 years, my 73 years of existence, is nobody reads anything. I took a reading comprehension test and got a 12 on it. The guy said nobody in 50 years has got a 12 on a reading comprehension test. And I said, what does that mean? He says, well, you're normal for the amount of education you have. And I have a law degree, and I told him that. And he says, well, you have a normal reading comprehension for the amount of schooling you have. I said, what is the average score on a reading comprehension test? He says, a 5 or a 6. I said, what is that? And he says, a grammar school reading comprehension. So the average adult male in this country has a grammar school reading comprehension. And I'm sitting here reading these deeds of trust and saying, how could they be getting away with this? They tell you right in the deed of trust that the loan isn't in default. In fact, any default or any delinquent payment can be made at maturity. Does anybody have any questions about what I'm talking about?
I mean, we just riding with you. There's a lot of people with their hands up. You want to take some questions? I can, I'm sure.
You're not bringing up. Everybody should be filing an heirs and omissions claim, and this is what I do when I do when I take a foreclosure case on. I file a heirs and omissions claim with the title company. I'm the only one that has ever done this. And I file an heirs and omissions claim with the Division of Insurance for insurance fraud. Because there was no title insurance at closing, the servicing company has no insurable interest. So how can there be a loan if he doesn't have an insurable interest?
That makes a lot of sense. I've
got a book. What they did is they hired, this guy's name is Philip Schonbucher. And I'll spell his name. It's Schonbucher. This guy's a head of the Technical Institute in Zurich, Switzerland, which they call the ETH School of Mathematics. He wrote a book on credit default swap agreements, and he goes into the actual mathematics and formula that they use to put these loans in default. This is an actual science. And I understand this because I'm a scientist. That's why I'm so good at this legal work, because in my chart I have an atomic formula. And I teach astrology. I've been doing it for 50 years. And I quit doing it when I started doing all this legal stuff. And I found out, and I started doing research, and I found out what's really going on, what they're really doing with these loans. And if you read, Ellen Brown wrote an article on this, and if you go into 1821 of Title 12, which comes from the FDIC regulations, it says that what they're going to do is and this is all being done under contribution and indemnification, which is contribution among the Joint Tortfeasors Act. And every state in the Union has adopted this. And this is all Admiralty Maritime law. Contribution and indemnification are all under maritime law. And the guy that wrote and I have a law review article written by Francis Gorman, and there's a couple other guys that I know personally. I know these guys personally. I've called them up and talked to them. And this is all maritime law. And under maritime law, if you commit, it's called privity and knowledge. And this comes from general averaging contribution in maritime law, which is shipping law. And what they do is they call it a peril of the sea. If a storm came up and a ship was in danger of sinking, if they sacrifice, this is called flotsam and jetsam. If they throw the cargo overboard to keep the ship from sinking, everybody that has cargo, everybody that's a passenger on the ship has to pay for the loss of the cargo. This is why they call it general averaging contribution. And they're applying the same principle to the American people. If you study the AIG, American International Group, which is owned by Henry Kissinger, which is a reinsurance company, and what they were doing is selling credit default swap agreements. Well, the IMF fund bailed them out, and how they did it, I actually contacted the attorneys and told them I wanted to buy all the stock in AIG. But I was moving at the time, and I never got back to them to do this. I could have bought up all the stock in AIG. I could kick myself for not doing it. Because the American people own GMAC, and all these companies are being bailed out by the American, by the IMF fund. They're bailing out all these banks, so you own all the stock in GMAC, and 70% of the stock is owned by the IMF fund or the Department of Treasury, and they're using taxpayers' money to bail them out. And what they've got planned is they're selling these defaulted securities to investors who are discovering they're worthless. So what they're going to do is they're going to confiscate everybody's bank account. If you go read 1821 2A of Title 12, it tells you that the corporation, which is the FDIC, succeeds to the depositor. That means succession, and succeeds means replaces. So what they're going to do is a liquidation. When they do a liquidation, they always appoint a receiver. And the Federal Depository Insurance Corporation, because every account is insured for $250,000, but you're talking about a $700 trillion industry. And this is what they did in Cyprus, in Greece. They liquidated everybody's bank account. They took 50%, to as much as 50 to 70% of their money in their bank account, and liquidated it to pay for these defaulted derivatives, worthless derivatives that they're selling. And that's what they're going to do here. They're actually going to take your Social Security, too, which is your retirement fund. They're going to confiscate everybody's retirement fund and their bank account and checking account. This is what they got planned. This is not hypothetical or conjectural. It's concrete and evident. I got the actual laws and the agreement between the Bank of London, England, and the United States to do this. This is what their plan is.
Wow. Well, hey,
Gene, you want to, and this is all insurance. This is all contribution. If you read Matthew 24:21, it says, "There shall be great tribulation." The word contribution comes from tribulation. So just substitute the word. 24:21 of Matthew says, "There shall be great contribution." Well, isn't that what they're doing? Everything is contribution. And it's pro rata and degree of fault. If you are is passive and active and passive and primary and secondary, which is degree of fault. If you are liable, if you commit an overt act that contributes to a loss, you can't collect on the claim. That's called primary liability. And in California, they have the degree of fault rule. And my brother, who's a judge here in California, is sitting on the Alban Waddell case, which is this guy suing Waddell for breach of contract because he's the largest Anybody that lives in California will tell you that California has the greatest wine, bar none. The best wine in the world is grown in California. They're the largest distributors of wine in the world. And this Waddell is one of the biggest growers of grapes for the wine industry in the world. And they're being sued in Superior Court in St. Louis Obispo, and my brother is the presiding judge. So I got in a conversation with my brother about this. And I haven't even read the case, and I asked him, I said, well, what are they suing him for? And he says, for breach of contract. And so he was telling me what was going on, and I said, you know what this is going to boil down to is assumption of risk. Because what they did in the contract is they said that we don't assume any liability for a defect in the grapes when we create the wine. That's called assumption of risk under contribution. And I said this is degree of fault. So they have to show to show that Waddell was liable. They have to show degree of fault, that they committed an act that contributed to the loss. Because they're claiming that they lost revenue because of the defect in the grapes. That's why everything is everything. What part of everything don't you understand is insurance? It has nothing to do with a mortgage loan. It's all insurance. Now, I'll take any questions you want. So what I do is, before I go into court, I file an insurance claim. And what you're doing, if you understand the Administrative Procedures Act, which is Title V, Section 152 through 172, it's got about 20 or 30 sections in it. You have to exhaust your administrative remedy before you go into court. And everybody's going into court and arguing all this mortgage shit. Where's the note? There's no note involved in it. There's no mortgage. It doesn't involve these judges laugh every time they go to the bank. Everybody tells me, well, the judges are all crooked. You can't win in court. You know what they do when I file paperwork? They take my case off calendar. Every case I've done, they take them off calendar.
Now, that's interesting that you say that, Gene, that everything is insurance, because we've been talking about that in taxes and so forth. But
you know who runs the banks? The insurance companies. AIG is owned by Henry Kissinger. It's all insurance.
It's all insurance.
Underwriting.
Underwriting
bonds,
right?
You know where the word underwriter comes from? They used to take the owner of the captain, the owner of the vessel, used to go to an insurance company, and he would get an insurer to underwrite to protect he'd do an indemnity and contribution policy on the vessel in the event of a loss or risk. And what he would do is get the underwriter that means what he would do is sign his signature under the signature of the ship owner. That's where they got and this comes from British shipping laws. The word underwriter comes from British shipping laws and Admiralty Maritime Law. And
that's what
all Admiralty Maritime Law is insurance.
That's what they're getting us to be, the surety, right? That's what we are.
Right, you're the insurer.
That's right.
Do you have an insurable interest? You bet your ass you do, but you never file a claim for a reimbursement or restitution. That's why the Dodd-Frank Act says that you have the right to set off a recoupment as a defense to foreclosure, and nobody reads the Dodd-Frank Act, which regulates all these credit default swap agreements. They regulate it. Dodd-Frank Act regulates it. I'll guarantee you there isn't one person that knows the Dodd-Frank Act. I've read the whole act. I've got all the code sections. And all of these people, that's not a permissive bank activity. They cannot sell credit default swap agreements. because they're deregulated. And that's not a permissible bank activity, because in order to sell credit default swap agreements, you have to be a derivatives organization under Title VII, Section 1, which is the Dodd-Frank Act. And none of these banks are licensed derivative organizations under Title VII, Section 1. None of them. So they're doing illegal activities.
And they get away with this because we don't bring it up.
Yeah, you don't bring it up, and you can't bring it up if you don't know what's going on. How are you going to bring it up if you don't know what's going on?
Beautiful. Hey, I got a lot of people with their hands up. We got about an hour left on the show. Feel like taking a couple calls now?
Go ahead.
All right, okay. Let's start it. Let's start in area code 786-7667. You're on High Frequency Radio.
Yes. Thank you, sir. My question is there a possibility that this gentleman would take a case and I don't know how much his fees are, but could he take a case of a foreclosure?
Yes, you're right. My answer is yes.
And could you the payment could you take a lien against the property yourself?
I could do well if you could make me. Here's another thing that you're not aware of, and this goes to the birth certificate. Everybody talks about the birth certificate, but they really don't understand it. And I'm not avoiding your question. I haven't brought this up yet because it hasn't come up for discussion. But everything starts with the, and I'm going to call it what it is. It's not a birth certificate. It's a death certificate. I had a guy one of my clients went into a county recorder's office in Michigan. 4 of them. There was 4 witnesses to this. They went into the county recorder's office, tried to record the certificate of live birth to show that they were alive and not dead. And you know what the clerk said? I can't record this because it's a death certificate.
I see.
So I started listening, and then they went away, and they came back a week later, and she denied that she ever said that. But she let the cat out of the bag. And there's a reason that you've been proclaimed, and it has to do with how many of you know what refunding bonds are? I'll guarantee you that there isn't anybody that I've met. Do you know what a foundling? You know what a foundling report is?
No.
Okay, a foundling report is a report that they file on the abandoned missing children that are reported missing or abandoned after 7 years. Now, some states have a 5-year rule, and some of them have a 7-year rule, which goes to the Cestui Que Vie Act under 1666, which is if you're missing at sea for more than 7 years, a presumption of death is created. Now, you have a presumption of death. That's not a finding of death. There's a big difference. If you read Title 31, Section 3128, it says there has to be a finding of that's why you guys, they're not crediting your redemption. That's why you're not being successful with redemption, because you've been declared dead. There's been no finding of death by an agency of the government. So what I did is I called up the IRS and I told them I wanted an EIN number for a foreign grantor trust. And they gave me an EIN number for the foreign grantor trust. Then I asked them for an EIN number for my estate. I told them that I was deceased, dead. They said, "When did you die? And when did this guy die, the decedent?" I gave them the year and the month that he died, and they asked me if it was being probated, and I said, "Yes, it is." And I told them I was the executor of the estate. So they issued me an EIN number, so I have an EIN number from an agency of the government that says I'm dead.
Wow.
What they did is they took your name. If you go look at your birth certificate, it's got your mother's maiden name down it. Every one I've seen, the only birth certificates that are legitimate are before 1800. I've got a birth certificate where they actually have the mother's real name, the husband, surname is on the birth certificate as the father. But what they do is they put the mother's maiden name down as the mother. That means the child was born as a bastard or illegitimate child under Deuteronomy 23:2. And Deuteronomy 23:2 says, "No bastard or illegitimate child shall enter the congregation of the Lord or Yahweh, even to the 10th generation." So what that means is that you have no inheritance or legal estate because you have no father. You were born out of birth, out of wedlock. So you're an illegitimate child, and if nobody claims you, you're deemed to be abandoned or missing. So the state assumes under the doctrine of escheats, it reverts back to the state, and the state becomes the administrator and executor of your estate. And they issue a refunding bond. A refunding bond indemnifies the executor or administrator, who's a county official in the probate division of your state you're in, is acting as the administrator and executor of your estate.
Okay, what happened is my mother passed away, and she had a reverse mortgage. So the bank, I don't think I'm allowed to tell you what bank it is, but this one particular bank sold the loan, or they told us they sold the loan to another bank. But the bank that has that the loan the money came from, it's not, they're the only ones writing us. And B of A came and said, "Listen, you got to pay us this money before the year is up, or you got to move, or we're foreclosing on your property."
You know who owns Bank of America?
I beg your pardon?
You know who owns Bank of America?
I have no idea.
Yakuza, the Japanese mafia.
Wow. Well, I think I better pay them then, huh?
Well, you don't have a loan. Why should you pay them?
I'm trying to make sure that I've already started some of the paperwork, the affidavits, asking them how much is it, because what's happened is I live in Miami, and I live in a district where it's being.
I got a case right now in Miami where it's been sitting there for 3 years. And I'm filing default judgment. I put in they never answer when they file a complaint. What I do is I copy the complaint and I put an answer in there with all these affirmative defenses. And invariably, what they do is they do and all of them, every note that I've ever seen has got a restrictive qualified endorsement on the back of it, either as an allonge or on the last page of the note. And I don't care if it's an adjustable rate note, a promissory note, an interest-only note. They endorse them with a restrictive qualified endorsement under 3-206, which discharges the drawer and the maker.
Well, what we found in our loan papers was that the anchor bank actually got more money, and they gave us what they wanted to give us, and then they made another loan with the balance of the money, and once they gave us the papers, they crossed out the loan number on those documents. The loan number was totally crossed out. That's not normal, is it?
No, it's not. Well, is anything normal in fraud?
No, it's not. So I'm very interested to know whether or not we can talk again, and what is the best way to contact you?
I have his information. I'll get in contact with you, and we'll set something up. You
need to get into my classes, and I'm not. I've got about a dozen people that I teach classes on Wednesday nights, and I charge $25 per class. And we have a class, a 2-hour class every Wednesday at 6 o'clock Pacific Standard Time.
Okay.
And I have a PayPal account that everybody donates money into for the class. And I give out handouts. I do handouts, and I tell people what they're doing wrong. And I haven't met anybody, and I'm not slighting people because people don't read anything. And see, my problem is I think everybody's as smart as I am, and I'm finding out that they're not. And
Gene, let me interrupt you real quick. I just got to make a quick announcement. To everybody listening, we got about 2 minutes left on the stream, all the people listening on the internet. So if you want to Skype in, you can Skype in. We've got about another hour left on the presentation. The phone lines are open. The number is 424-222-5250. Once again, that's 424-222-5250. If you're not going to continue with us, you can catch this call in our archives, and you can go to blogtalkradio.com/high frequency. You can hear all our audio calls in our archive section. Okay, sorry about that, Gene. Go ahead and finish your thought, what you were saying.
Okay, you can actually, they owe you my, I've got 10 cases that date clear back to the 1850s. That when you see, everybody thinks that a note is a liability instrument. Excuse me, it's not. And it says in 3-104D, and I'm going to quote what it says. It says a promise to pay is a liability instrument. An order to pay is a draft, and the person entitled to enforce it may treat it as either. Once they endorse it with that restrictive qualified endorsement, they're treating the note as a draft. And they use that as the escrow, and I actually have a MoneyNet daily transaction report, log report. It comes from the CMIRs, Currency Money Instrument Reports, FinCEN Forms 104, FinCEN Form 105, and FinCEN Form 8300. And it shows the source bank as the borrower and the target bank as the borrower.
You mean the lender?
No, it shows the borrower as the lender and the servicing company as the borrower.
Okay.
And under the Bank Secrecy Act, there's a company that publishes an actual practice on this is money laundering and racketeering. And they have and you're not aware of this. I haven't found anybody that's aware of this. I subscribe. This is an actual subscription that I subscribe to. And they send you all these rules and regulations, and they have what they call a death penalty act, where if a bank is caught laundering money or engaged in racketeering, they revoke their insurance under FDIC, and they revoke their charter under the Comptroller of Currency. Are you aware of that?
No, but who is the administrator of that rule? The SEC?
The Comptroller of Currency. It's in the National Bank Act. Did you know that in the National Bank Act, Section 27 and 35, it says that they cannot hold a mortgage, they cannot hold real estate as a mortgage for more than 5 years. And they can't use a circulating note. Well, once you give them a promise, let's assume for the sake of argument that the note is a promissory note. They can't take that. When you give them the note, it becomes part of their circulating notes. they can't use circulating notes to procure money for their capital stock. What the hell are they doing? They're selling the note to investors and getting capital from it. That violates the National Bank Act of June 3rd, 1864. How come nobody's bringing this up in court? You ought to see this case. I just filed this in New Mexico this week. A motion to strike the complaint as redundant. It's conclusionary. It assumes evidence. It assumes facts not in evidence. It calls for a conclusion of law. The attorneys are incompetent because they're given fact testimony. They don't have personal knowledge. Under Rule 601, which comes from the dead man statutes, they're giving fact testimony on behalf of a dead person. And I said, I have an EIN number for the estate that shows that this person was deceased at closing. I said, how does a dead person sign loan documents? The only way you can transfer ownership in a loan is by probate or will when a person is deceased. So I tell them I'm the executor legitimus of the estate of the decedent, Gene Keating, by intestate succession, by descent and distribution, by intestate succession as a beneficiary and heir at law. They call it the Simultaneous Death Act. Every state has adopted it. And I'll tell you another thing that nobody reads is the probate codes. Did you know that a trustee has to sign a trust under the probate code? And all these deeds of trust have a trustee, and the trustee never signs the deed of trust, so the deed of trust is invalid. If you go into Blackstone's commentaries and read his commentaries on the laws of England, when you have a trust, the borrower has to sign it, the lender has to sign it, and the trustee has to sign it. None of them sign anything.
Well, speaking of trust and deeds, what they wrote and told me, the bank wrote and said that because we did not have a trustee deed, that there was no trust. There was no trust owners or deed owners, but the property is in my brother and my name, and also
sure there's a trust.
They asked me to send them my birth certificate to prove that my mother was my mother, and I did, and they never responded.
You don't. Your mother had you out of wedlock. You know what the doctrine? You know what? Do you understand the doctrine of parens patriae?
No, I don't.
Okay, the church is under the doctrine of parens patriae. That's why the Pope is referred to as the padre, as the father of the congregation. You know who has all the original birth certificates? The Roman Catholic Church. The Pope does. Do you know that every judge files his oath of office with the cardinal bishop in the diocese in which the court is located? Did you know that the cardinal bishop of the diocese in which the court is located is the Lord High Chancellor in equity under the King's Bench?
So how does that relate to my situation?
I do a relator. I do an XRL complaint in the name of the Pope. I put the Pope down as a plaintiff. I put the Pope's name in there. And this law firm contacts me and said they're representing the Pope, and I said, no, you're not. And I backed them right down. They told me I had to take the Pope's name or the Cardinal Bishop's name off the paperwork. I put his name down there as a relator, XRL, in the name of. Well, it's a Queen Ham action, is what it is.
Because Gene, you might be losing. What I was going to say, you might be losing some people because people got to understand how the church and the court are interrelated. You know, I even had a question. Somebody also asked the question, can they redeem their children if the children are under 7 years old? Can they go and file paperwork and redeem their children back?
Yes. You can if the parents are still living. You have to change the birth certificate and put the real names down. You can do that. You can change the birth certificate. I know somebody that did this, and he did it in Florida. I have the paper.
I got a friend who's making some change to his birth certificate because they had the name wrong. They make you submit an affidavit or something. They got a little procedure to do it. But that's interesting.
Do you know what it's called? Capatonym. You know what a capatonym is? Do you know what a holograph is?
I know what a holograph is. I don't know what a capatonym is. Never heard of it.
A capatonym is a word that when you spell a word, a proper name in all capital letters, it becomes a capatonym or a homograph, which means that it's a composite of 3 or more words that have 3 or 4 more different definitions. And when they record this under Title 50, Section 19 of the Trading with the Enemy Act, they have to interpret what the name says. It's not a name, it's a word. And you take it as a name. When you go into court, and that's not only not a name, it's not a word. It's a word, not a name. You do not spell a person's name in all capital letters. It's not a name if it is.
That's interesting. It's like an item sold, and it sounds the same, but it has a different meaning.
Yeah, so you go in there, and they say, are you Gene Keating? And I went into I used to get in a lot of fights, but I'm not going to go into that because that's not germane. Suffice to say, I used to beat people up. If I didn't like you, I'd knock you out. When I hit people, all my fights were one punch fights. I could knock people out with one punch, and I did it on numerous occasions. That's how I got my legal experience, so going into court. And I went in, I worked as a cook, and this guy was insulting the waitresses. And I said, if you talk to me like you talk to her, I said, I'd knock your ass out. So he started talking shit to me, so I knocked him out. I hit him so hard his shoes were still on the ground. And he fired me. So I tried to collect unemployment insurance. And if you know anything about unemployment insurance, you can't collect unemployment insurance if you commit an overt act that contributes to your getting fired. And I definitely, I hit this guy so hard I broke his jaw. And so I had a hearing. So I went into the hearing, and the woman that was running the hearing, the unemployment insurance hearing, remember, this is insurance. And so I go in there, and she asked me if I'm Gene Keating. And I said, well, what's your name? And she wouldn't tell me who she was. I said, well, I'm not going to answer your question until you tell me who you are. I said, who the fuck are you? Pardon my French.
No, that's okay. They do that a lot. I notice when you talk to them, you ask them for their name, they never want to give you their name, but they're always trying to get information out of you.
Well, that's because they're making a contract with you. They're trying to get you to give them your name. And so I asked her, she gave me her name, and I asked her, I said, do you have a claim against me? She wouldn't answer the question. I said, I'm going to repeat the question. Do you have a claim? And finally she said no, and I said, I'm out of here. And I walked out of that hearing, and I collected my unemployment insurance.
Wow. And I tell people that on this show, one of the most powerful questions I've ever used in court against public officials is, do you have a claim against me? Do you know anyone who does have a claim against me? I hit them with those questions all the time.
So that raises the question. He's going to say no. So what the hell are you doing in the courtroom if they don't have a claim against you?
Exactly. Okay, hey, real quick, because we got a lot of people, their hands up. Area code 786. That got your question answered, I'm sure, for the most part. I'm going to give you the information. I'll get in contact with you, and I'll make sure you can also, everybody, if you have questions I don't get to you can email me at highfrequencyblogtalk@gmail.com, and I'll forward everything to Gene. If you need to get in contact with him, things of that nature, okay? Let me get some more of these calls real quick, all right? All right. Let me get area code 508-7632. You're on High Frequency Radio.
Yes, good evening. Yusef.
Greetings.
Yes, greetings. Peace. I don't really have a question. I had a hard drive meltdown on my desktop, and I need to get back. I need you to get back into that the Dropbox. So,
well, just send me an email at highfrequencyblogtalk@gmail.com, and I'll just put you back in. Just say put in the subject line Dropbox, and I'll put you back in.
Okay, I sent you one last week, and I didn't get a response, but I'll send you another one. It's
send me another one. Send me another. I got like about 600 email requests. I got to go through them all. So, and I'm not exaggerating.
I appreciate it, man. I believe you. I appreciate it. Okay, peace to all.
Peace.
All right, thank you.
All right, let me bring in 804-8917. Hold on. I get 317-4330.
Yeah, this True Free, man. What's going on?
Hey, what's going on, True Freeman? How you doing?
All right. I just want to elaborate a little bit, or basically put my 2 cents in on what I think it was the caller. I don't think it was Gene that said it was the caller talking about that we presume dead, and the caller that said they were up in Michigan and went in and tried to record the certificate of live birth, and in fact the certificate of live birth is a certificate of death. I had mentioned that a while back. That's why I never really tried to get worried about getting the certificate of live birth. But I mentioned this a while back and thought about it, and I want Gene's take on this, as well as the caller, if he commented, wanted to call back in, because I feel like this. The coroner is an elected official. He is the only one that can pronounce you dead. He's the only one that also can pronounce you alive. In order to claim life, because a lot of people are trying to do the claim of life, which I'm under the impression that was what he was attempting to do. The only way you can claim life is through the coroner, because the coroner pronounces you alive or dead. I think the coroner is totally involved in this more than people even want to think about. They're leaving out the coroner. The coroner is the only one that can pronounce you dead. He had to have something to do with declaring us to be dead, whether it be the strong man or the living person. We know we're not dead. So I mentioned it a while back. Like I said, I think we need to figure out a way to dress the coroner and actually get a certification that we, in fact, are not dead, that we are alive. I think that's the only way to claim life.
Well, I know that the coroner also is the one responsible for putting a check on the sheriff, at least in history. Gene, what is your take on what he just said about the coroner? Because I'd heard a long time ago that they put paperwork with the coroner's office. I'm not sure if there's any credence to that, but have you heard anything about that?
Go read Title 31, Section 3128. Any government agency can do a finding of death. Remember, a presumption, if it isn't rebutted, if you get I've got a finding of death from the IRS. And they're not a coroner. Remember, not aware of. Every state has adopted presumption of death statutes, and it's in Title 38. It's the federal statutes that create a presumption of death. So they have presumption of death statutes. Everybody is presumed to be dead. So what I do is I go into court and give a finding of death. So I get them to what I do. That's the same thing as a death certificate. I bring in the letter from I got a letter from the IRS that says I'm deceased.
Now, okay. Now, because I teach that too. That you get the go to the IRS and get you an EIN number for a foreign grantor trust, and also get you an EIN number for the estate and all that. How are you saying that plays into that? Because they do ask you that question. Well, this is for dead people, and I said, yeah, they are dead, and
yeah.
And people are getting...
When they issue the estate number, the EIN number, you become dead. That's a finding of death. Because it's if you read Chapter 11 and Chapter 12, all it talks about is decedents, dead people.
Now, now hold on. Now, them declaring that that you're dead, because I hear some people getting like checks for doing this, from their estate, and people coming back, getting arrested or whatever, how, because we need to qualify this word death is what I'm getting at. Because, you got a civil death. When you say you are dead, obviously you're not really dead. But are you dead on the public side because this is a corporate entity that is dead?
But it's a finding. It's a finding of death. Okay. You don't have to be, in other words, it's no longer a presumption. They found you as being dead. There's evidence that you're dead.
So that's almost like validating that this is a corporation, a corporate entity.
Right. And if you read 303 of Title 26, it says corporations are decedents.
Exactly.
And I said, you're incompetent because you're deceased. I tell the judge that he's giving fact testimony under the dead man statutes without personal knowledge. He doesn't have personal knowledge, and he's incompetent to testify on behalf of a dead person. Did you know that that the word mortgage comes from the word mortmain, which comes from the Norman conquest of 1066? Mortmain means dead hand, and it only applied. It only applies to ecclesiastical corporations. So what they did is the king issued an edict that they were going to start applying it to corporations, corporations. So they declared corporations dead. So they had to give them a remedy. So what they did is they took and that's when they passed charitable organizations. A nonprofit organization, which is a charity, a 501c3.
Interesting. True Freeman, I had muted your mic because you had a lot of.
So they pass it off as a nonprofit. If you're not making a profit, then you can take money out of it. And so what they did is they got around the mortmain, the doctrine of mortmain, and so under mortmain, which is where the word mortgage comes from, which means dead hand, and so dead hand comes from mortmain, and mortmain has to do with civil death, and all of these corporations are civilly dead. Why are they civilly dead? Because they're bankrupt. Any bankrupt or insolvent company, association, or corporation is civilly and legally dead, is naturally and legally dead. I have a Supreme Court decision that says that. In fact, I have a dozen of them that says that. And I bring this up in my paperwork. I tell the judge that these attorneys are civilly dead. And they're up there giving fact testimony on behalf of a dead person. You can't do that. That's where the dead man statutes were passed. You couldn't come into court and testify on behalf of a dead person. That's why under Rule 17 of the Federal Rules of Civil Procedure, it says the only person that has standing And capacity to sue is an administrator, executor, trustee, conservator, guardian, administrator, or executor. There's about 7 different entities under the federal Rule 17. And they have that in the state rules too, and I use these. I said, this person doesn't have capacity or standing to come. See, you have 2. You have prudential, you have capacity and standing. And you have the prudential requirements, which are real party and interest. They're 2 separate and distinct. You can be a real party in interest, but not have standing or capacity. And you can have standing and capacity and not be a real party in interest. And they never join the investors. And you know, Rule 7, if you read the Henry Kwang case, which is 326 BR 725, and you can download it off the internet. The best case I've ever read on mortgage foreclosure cases. They tell you in there that Rule 17 came from Rule 19, which is joinder of parties. In other words, because there's a REMIC involved in this, they have to join the REMIC as a plaintiff before they can foreclose on your property. It says there that they can't adjudicate that because there's indispensable parties under Rule 19. They can't adjudicate the case without these people joined as real parties in interest.
Wow. That makes sense.
How many people know that?
That makes sense.
I boilerplate this. I've got an argument that's unassailable. They cannot get around. They just take the case off calendar because they don't want to deal with it. Because if it goes up on appeal, it collapses the entire mortgage industry.
Wow. Let me take another caller. Real quick, Gene. Let me bring in another caller. 267-3782. You're on High Frequency Radio.
Yes. Good afternoon, Yusef. How are you?
Good afternoon. Fine. How you doing?
Good. It's a pleasure to hear Gene on the call, and I thank him for being on. I was thinking about what he said earlier about people don't read. It's not that people don't necessarily read. It's all about comprehension. We can read stuff, but if we don't comprehend it or know all the legalities behind it, then, yeah, it's hard to understand. So, yes, I guess we all should go through Black's Law Dictionary and do a word thing. But anyway, my question was, with his classes, that's every Wednesday. So that's basically on the computer?
Yeah, we do an Acrobat. I have Acrobat Reader, and you can actually see my screen. You can't see me, but you can see the screen, and you can see all my documents that I have on the screen. And I show documents to people on cases that I file in court and how they rule. Like I've won every case that I've done here in California. I have a foreclosure case in San Bernardino. The judge threw the case out.
Okay, Gene, what do you have available that's similar to that people can get through the mail who is not online?
Well, I've gotten into motions to dismiss. I strike the complaint because none of these attorneys, all mortgage foreclosure complaints have to be verified.
No, what she said, wait a minute, Gene, what she's saying is she don't have a computer.
I'm not online, and I don't have the funds to be online. So what are my options to get a hold of?
She wants to get a hold of you.
A CD or DVD.
She said, do you have like CDs, DVDs you sell, or anything like that?
Or call-in number for
we record the classes. It's an actual recording. I can send you the recordings.
Okay. So how do I go about getting that information and get the recordings? Do I just go online to a website or something?
You contact Glenn. Glenn Tuttle runs my classes, and he handles all of the, because I don't have time. I'm so busy with doing paperwork. I don't have time to do all that, so he takes care of all that. I can give you his contact information.
Okay.
If you'll send me an email, let me give you my email. It's JEAN Keating, CEATING @gmail.com. You want me to repeat it? I'll repeat it.
I think you said JEAN CEATING @gmail.com.
That's correct.
Okay, good. Thank you, Gene. The other question I had is for Yusef. You were talking earlier about minimum contact, and you spoke of the driver's license, the birth certificate, and the Social Security card. So, I mean, it wasn't like we understood what the instruments really were. So, do you have any insight as to what to do with those three particular documents?
Well, they're in the decedent's name. They're in a dead person's name, so they become part of your estate.
Okay.
Just like when they don't transfer these loan documents to the REMIC, all that capital becomes part of their estate. Did you know that? It becomes taxable income under 2036A?
No, 2036A.
And then you want to transfer that estate into a trust.
Yeah, you can transfer it into a trust, and you don't have any. You have a under Class 5 all 1099s, 1096s, 1098s, W4s are all Class 5 gift and estate taxes.
Yep.
That means you have a $1 million exclusion on the gift side and a $5.5 million exclusion on the estate side. So unless you make over $5.5 million annually, you don't have any tax liability. And I talk to people that are in the tax business, and I said, you guys don't know tax law at all. I said, why are you telling people that they have to file a 1040 tax return? I said, do you know what a 1040 tax is? I was at a bar, and I was drinking beer, and I was eating dinner. I have a pub down the street here I go to when I want to relax, because they got good beer, and all their food is home-cooked. So I go down there. So I'm sitting here at the bar listening to this guy talk to his girlfriend. And he's telling his girlfriend that he has to file a 1040 tax return and pay his taxes next week. And I asked him, I said, do you know what a 1040 tax is? He says, no. And I said, why are you filing 1040 tax returns if you don't know what a 1040 tax is? You know what he told me?
No, what?
He told me that he was an ex-IRS agent.
Okay.
Doesn't know tax law at all.
Yeah, you know, that's one thing JT was saying, too. He said these IRS agents don't know any tax law.
I have an IRS lien that came off of a county recorder's office out of Miami, Florida. And it says that they did an assessment. It shows the assessment and the lien. And it says that the lien is on a 1040 tax. So I went in and started doing some research into what a 1040 tax is. It's a tax on farm property on an alternate valuation on a carryover basis. I said, well, what the hell is an alternate valuation on a carryover basis? So I went into Title 26, Section 2032A, which defines what an alternate valuation. I said, this is talking about a dead person. It shows the value of the estate at the time of the death of the decedent, 6 months after the death of the decedent, and the value of the estate at the transfer, disposition, or sale of the estate property. I said, wow, this is talking about a dead person. Now listen to this. This is really going to blow you away. So I went in there and I said, this is talking about dead people. I said, this guy isn't dead, so why the hell are they taxing him? And so I have a girlfriend, I have a client. She's actually my girlfriend. She's in New York. And she was going through a foreclosure, and in the mortgage security agreement, it says as a condition of the mortgage security agreement, she has to pay all the property taxes. And so they foreclosed on her because she didn't pay the property taxes. So I went in there and did some research on what she lives in New York, and under Section 300 of the real property laws, it says that if your property has a situs in New York, it's taxable. And I said, well, that's interesting, and I found this website, and this woman has property. She lives down in Florida, and she has property in New York, and they said that her property was taxable because her property had a situs in New York. And her real property became part of her estate. And so I said, well, I wonder what the word situs means. So I go into Wiktionary Dictionary, which is part of Wikipedia, and it's run by Jimmy Wales. I know Jimmy Wales. I talk to him all the time. The guy's really smart. And he says that the word situs, you know what the word situs means?
No.
It means to be dead or to be interned.
Now,
they're imposing what you call an ad valorem tax is a death tax.
Okay, Gene, when you say situs, how do you spell it? How are you spelling situs?
S-I-T-U-S.
Okay. Now, I thought situs in a Black's Law Dictionary meant the location of something. Is this a different sense that you're using it in?
Yeah. You're looking at it. You go to Wiktionary Dictionary. It tells you it means to be interned. It's a passive participle of the verb to be dead.
That's interesting.
So what they're doing is imposing a death tax on your property. So I wrote this Tower Capital. You ought to read this letter of rogatory I put together for her. Do you know they dropped the whole thing when I sent them this this? I challenged their authority to make a presentment on as a third-party debt collector.
You know what you
what
do?
I did is I called it, and I found out Tower Cat.
I want you to do this for me, Gene. I want you to do this, but I want you to read that letter if you got time. I want you to read that letter, because that's a badass letter. People need to hear it.
You want me to do it right now?
Yeah, read it. I want you to read that letter, because I remember you read a letter similar to that long time ago, and I tried to transcribe it, because I said, damn, that letter is bad. And I actually got a transcript from something else that you did, where you had another letter. It was for a foreclosure, and it was talking about the FR 2046 and the 1099 and all that. But, yeah, you read that letter to me last night. Read that letter. Go ahead and read it.
Let me find it here first.
Okay.
I've got so many letters that
because that was a nice letter. I mean, it was like you were basically now this was a letter of rogatory that you were sending to the judge in chambers, right?
No, this is a letter I sent to Tower Capital, as they hired Schenectady County hired them to foreclose on her property because she wasn't paying the property taxes. And I called this guy up and I asked him. I said, I'm an investor and I have your prospectus, your S3 and your 424B5 prospectuses, plus the call schedules and reports. And I said, I'm interested in buying your certificated securities and bonds. Oh, he couldn't tell me enough. He sold the farm. He told me everything he was doing. And so I drew up this letter rogatory based on that.
So you just came and posed like you were interested in buying
all these foreclosure properties as an investor. See, and he couldn't talk fast enough. He actually sold the farm. I laughed my ass off. I thought that was the funniest thing. I did this with I talked to the chief legal counsel for J.P. Morgan Chase, and I disguised myself as an investor. See, and I'm talking to him, and I'm asking him all these questions, and he started laughing at me. We talked for over 3 hours, and I said, "Why are you laughing at me?" And he says, "Why are you asking me all these questions? You know more about this than I do." He told me that I knew more than he did. And I'm asking him all these questions, see? And I practically gave myself away because, I convinced him that I was an investor because of the questions I was asking him, see? And I know what an investor should be asking, the questions.
Okay.
Here's the letter. It says, overnight mail, Tower Capital Management, LLC, 10 North Park Place, Suite 300, Morristown, New Jersey. Kings Road, City of Schenectady. Tower Capital, they put the ID number in there, and the amount was $88,000 in property taxes. And here's what I said. I said, this letter is being written in response to your recent letter regarding an alleged assessment on parcel number 6038-2-1-21, 103 Kings Road, City of Schenectady. Tower ID number 143969, belonging to Franca Marie, family of Di Crescenzo, the executrix legitima of the legal estate of the decedent, Franca Di Crescenzo. I am conditionally accepting your offer to pay the attached tax bill and presentment under 3-50123 of the New York Uniform Commercial Code upon proof of the following claims and facts. 1. That Tower Capital LLC exhibit the original contract or agreement memorialized or subscribed to by Franca Marie, family of Di Crescenzo, as the executor legitima of the decedent, Franca Di Crescenzo, and the bondholders under the official statements for the county and city of Schenectady for the payments of the serial bonds and anticipation notes for the years 2009, 2010, 2011, and 2012 under the Statute of Frauds of New York General Obligations, Title 7, Section 5701, as agreements required to be in writing, and Section 1-206 of the New York Uniform Commercial Code under the Statute of Frauds, hereinafter contract, unaltered with original blue ink signatures. 2. The Tower Capital LLC send me documentation or certified documents evidencing that the gross estate and real property of the decedent, Franca Di Crescenzo, has a actual situs in the state of New York, county, and city of Schenectady under 951, 952, 960A of the New York tax laws, and Section 960A, 951, 52, 54, 55, 57, 58, 59, 60, 61, 62, 64, and 65, and 2103 and 2104 of Title 26 of the United States Code annotated. And number 3, the Tower Capital send me documentation, evidence, or certified documents that my real property has a taxable situs under Section 10.2 and 10.4 of Chapter 10 of the City Charter of Schenectady, I actually got a copy of their charter. That Tower Capital Management, LL, send me evidence, documentation, or certified documents that my real property is not exempt from the special ad valorem tax under Section 300 of the New York property laws. They tell you that there's property exempt, but they don't tell you how it's exempt. By not being dead is how you get the exemption. 5. That Tower Capital LL send me evidence, documentation, or certified documents that Tower Capital Management LLC or the City of Schenectady has paid the income or capital transfer tax on the serial bonds and anticipation notes under the official statement of the City of Schenectady, which are not qualified exempt organizations under 26 U.S.C. 265B3B1, which are issued after August 7, 1986, by a qualified small issuer. Number 2, which are private activity bonds, as defined in Section 141 of Title 26, and number 3, which are designated by the issuer for purposes of this paragraph, that the serial bonds and anticipation notes which will be issued by such issuer during such calendar years exceed $10 million. 6, the Tower Capital show me identification and their authority to act or do a presentment for payment of real property taxes on behalf of the City of Schenectady as mandated by 3-5012B of the New York Uniform Commercial Code. 7, that Tower Capital LLC sign a receipt for the instrument for payment made in full as accord and satisfaction under 3311 of the New York Uniform Commercial Code by securitization of the contract under the transfer and servicing agreement, and to surrender the instrument to me as mandated by 3-5012C of the New York Commercial Code. The Tower Capital LLC produced a scheduling balance sheet, RCC, showing financing receivables or assets, and RCL call reports evidencing securitization of the retail sales installment contract as an off-balance sheet item under the transfer and servicing agreement. These are all investment contracts. You're not paying property taxes. You're paying cash flow claims on an investment contract. And they collect it as if it were an ad valorem tax. Okay? And the accounting ledger for the above alleged account or credit transaction to show that Tower Capital is in compliance with FASB Standard Financial Accounting Standard Board's number 95 Statement of Cash Flows, and credited my payment as a cash payment and deposit and receipt as to pay or when the entry was made under 1813 L1 of Title 12. I also want to see the 1099A as an acquisition and the 1099 OID as an original issue discount, and the U.S. Informational Tax Return Form 1096 showing the capital transfer tax withheld and paid out as a taxable termination, distribution, or transfer by Tower Capital Management LLC as the servicer under a servicing agreement under sections 2511, 26032, 2611A of Title 26 of the Internal Revenue Code. Otherwise, Tower Capital Management LLC is in possession of contraband upon which a lien is attached under 6324C2 of Title 26 of the Internal Revenue Code until the capital transfer tax is paid in full. I want a copy of the RCS call report showing Tower Capital LLC assets or receivables that were sold or securitized for the first and last quarters of the accounting period. Schedule RCS should be completed on a fully consolidated basis. Schedule RCS includes information on assets that have been securitized or sold and are not reportable on the balance sheet. So they include them on the RCS call schedule as a condition of sale, except for certain on-balance sheet retained interest-only strips. subordinated securities, and other enhancements. Those enhancements are your credit derivatives and defaulted derivatives, as they talk about under the credit default swap agreements. 9. The Tower Capital LLC sent me a copy of their contract with the City of Schenectady and registration statement and license with the Secretary of State in the county and City of Schenectady to transact business in New York as a third-party debt collector under FDCPA 15 U.S.C. 1692 et seq. 10. That Tower Capital provide proof that any consideration was given to support the servicing and sale installment agreement under Article 2-306 and Article 3-305 of the New York Uniform Commercial Code. 11. You are required by oath of office and the Internal Revenue Code and the instructions on the 1099-As and the 1099-Cs to file a 1099-A or 1099-C when there has been a taxable termination, distribution, or transfer as a generation skipping transfer under 2611 of Title 26 of the United States Code. Please fill out and return the enclosed W-9 form in the event that Tower Capital Management, LLC, breaches its fiduciary duty to file a 1099-A or a 1099-C as required above, so that I may file these forms showing that Tower Capital, LLC, is the recipient of the funds as the transferee and liable for the capital transfer taxes as taxable terminations, transfers, and distributions. You are required to return this W-9 form to me under 26 U.S.C. 6109. Failure to do so imposes a $50 fine. See page 2 of the W-9 instruction booklet attached here. New York Constitution, Article 6. Attach 1. The judicial power of the state is invested in the Supreme Court, Court of Appeals, and Superior Court, all of which are courts of record. Statement of Financial Accounting Standards, number 95. Statement of Cash Flows. Footnote 63. FAS 95 footnote 1 says, consistent with common usage, cash encloses not only currency on hands, but demand deposits with banks or other financial institutions. That's why they have to file an 8300 form. Because when you went to closing, you did a cash transaction. A promissory note deposited in a demand deposit account is a cash transaction under 1813 L1. And the deposit becomes the equivalent of cash. Are you getting this? Does everybody understand that?
I understand. I know 1811 L1 says. I've read it so many times in reading your material, and I understand that the promise. I also know that the closing table is a financial institution. That's under Title 31, 5112, I believe it is, under the definition of financial institution. That shocked me that the closing table is considered a financial institution. You're basically making a deposit inside of a bank.
Yeah. Yeah, you're making a deposit. And they're not paying you for your deposit. They're not giving you a receipt.
They're not giving you a receipt. They're not giving you a receipt. They're not giving you a deposit.
They're not giving you they're not crediting the payment, and they're not giving you a receipt for the deposit.
Wow. That's 31. Go ahead.
Schedule RCL, off-balance sheet items. Now that's your RCL. That's the consolidated that shows the balance sheet. I showed this to a judge and he ran out of the courtroom.
And by the way, y'all, that's Title 31, 5312, subsection 5312 gives you the definition of financial institution. You can look that up. Gives you 26 definitions of financial institution, and you'll see right there that a closing table, everyone at the closing table is considered a financial institution. 31 USC 5312.
Yeah.
Real interesting. Hey, let me do this, Gene, because we're about to run out of time. I want to thank you. Go ahead.
This is rather lengthy. This letter goes into a lot. I put the actual. I have a copy of the official statement. The city collects these ad valorem taxes on your estate, and they use them as cash flow claims to investors. And I called the attorneys up and asked them, I said, where do you get the authority to forward my property taxes? I disguised myself as Mr. DiCrescenzo, and they hung up on me.
They basically secured that. Well, I'm trying to figure out how did they secure it, because you pay property taxes like once a year. So if they're cash flow claims, the certificate holders in the interest in whatever investment vehicle they're using as a pass-through for those cash flow claims, I mean, what are they using for that? Real estate investment trust?
Yeah, they set up a trust, and they issue anticipation notes and bonds to the investors, and they forward these cash flow claims to the DTC. All this is registered with the Depository Trust Company. They act as the beneficiary for the investors. Wow. I'm sitting here looking at this official statement that's filed with the, and I'm not trying to figure out what isn't an investment, not what is an investment contract, but what is an investment contract. Everything that you get, when you give money to people, do you know that all your utility companies are investment companies?
They securitized everything. Everything is going out to help people.
They securitized everything.
Everything has been hawked off. Everything is how to sell.
They do hook, line, and sinker, and they're making you pay for everything. And you're not getting any reimbursement or restitution because you're not demanding it.
Wow.
How do we demand from the utility company?
Tell them you want to pull their prospectus, pull their official statement.
I've never heard of that.
No, you haven't. Mm-hmm. I got about 1,000 of them on my computer. I've got 20 million files on my computer.
I believe it. 50 years.
Repeat that again, Gene. It's called a polar. Say that again. A polar.
It's called an official statement. They're all over the internet. I went into Schenectady County and pulled their actual, and then I got a copy of their charter, the city charter. And I went through the charter and I incorporated all that into this letter, and they dropped the whole thing.
Okay, how's that spelled?
Because they didn't answer my challenge. They don't have the authority to make a presentment on behalf of Schenectady County.
What she said, Gene, was how's that spelled? It's called a polar. You called it polar something. What was the term you gave to it?
Oh, you mean the polar?
Yeah. Bowler. How do you spell it?
I'm not sure what you're making reference to.
Okay, she asked you, she said, how do we make a claim against the utility company? And you said something about a polar. We didn't quite catch what you said. Do some kind of presentment to them.
Well, you should ask them for their official statement. You can download this off the internet. They're all over the internet, the official statements. They're actually all these attorneys are making money off you because people are asleep.
Okay, let me do this, Gene. All right, because we ran out of time. I'd like to invite you back if you're willing to come back, because there was a lot of people that wanted to ask you questions. I didn't get to everybody. I just kind of let you talk today, because a lot of my guests, some of them may be familiar with you, some of them are not. So I was just letting you just ride out. I'm sure they would love to have you back on for a little part two if you have time for that. But I do want to say this also, and I'll get with you in private. We'll talk about that. But I do want to thank you publicly because I have a lot of listeners, and I talk about you periodically on this show. And, you know, when I was going through my ordeal, when I first got introduced to this, the first time I ever heard about you was the Gene Keating transcript and the prison treaties. I mean, I was in solitary confinement. I was trying to get that prison treaty so bad, and I finally got a hold of it, or at least a portion of it. I know you told me that you have one that's much more extensive.
You know, it was only about 25 pages long.
Right.
It's now
right.
953 pages.
But yet and still, that 25 pages was some of the most comprehensive information that I had ever read. It inspired me to up my game because my first time I read your stuff, it was so complex, and I had to keep reading it, and looking up words and reading it, and then it began to make sense to me over time. And that's what I want to encourage all my listeners to do, because go back and listen to this audio. This is this is like a class that you've been given. You've been blessed. And if you didn't understand a lot of the things that he's saying on this particular, go back and listen to it. But I want to research it. But hey, we're running out of time. We got about 2 minutes left. I want to thank you, Gene Keating. If you're willing to come back, I'd love to have you back on the show. I'd like to get you to commit right now publicly, because I do got a slot open. Okay, I got a slot open tomorrow, and we'll get in. I'm gonna give you more time and let you get in on this. Remember, he has a class, y'all. But that's about it, y'all. I want to thank everybody. I want to thank you, Gene, and I will see y'all tomorrow.